business landscape all over the world can either be usual or unusual, depending on who you ask.
In Nigeria, the 2020 amendment to the Companies and Allied Matters Act, otherwise known as CAMA, has added to the level of how usual or unusual the business landscape will be in the country.
So, how will CAMA affect the operations of small businesses,
large corporations,
conglomerates,
voluntary organizations,
non-profit and non-governmental organizations? Banwo Ighodalo, a Tier 1 law firm in Nigeria, is committed to helping you understand the CAMA 2020 and the implications for your businesses. Listen and get the facts of the Act. Welcome to the new innovation in CAMA 2020, brought to you by Banwo Ighodalo. One of the first things to determine when establishing a business entity is the specific purpose it will serve. It is also expedient to know about taxes, liabilities, management and control, as well as how you receive profits and manage losses. In this podcast, Olumide Osundolire, a partner at Banwo Ighodalo, looks at aspects of CAMA 2020 that deals with the introduction of new types of business structures. CAMA 2020 has created new business structures in Nigeria, enabling promoters to register limited partnerships and limited liability partnership. What are the features of an LP and LLP?
Thank you. The features of the LLP and LP are as follows. With respect to the LLP, the LLP is a body corporate that is formed under Part C of CAMA. It is essentially a partnership that enjoys the rights and benefits of incorporation. And so the law says that upon registration, the LLP may sue and be sued in its name, acquire our own property and dispose of property in its own name, and it can do anything that a body corporate can do. So essentially, what you also have is that rather than have shareholders, because it does not have shares to distribute, rather it's a partnership. Members are called, the promoters are called partners, and a minimum of 2 partners can start an LLP, and they could be individuals or they could be companies. Every LLP will have at least what the law calls 2 designated partners. These designated partners, you may call them managing partners. They are the partners that will be liable or responsible to CAC for regulatory compliance issues that are listed in CAMA. And the law says that these designated partners must be individuals. Where the partners are corporate companies, the corporate entities must nominate individuals who will act as designated partners. Another interesting feature of the LLP, which of course draws from the name of the entity, is that the partners are not liable. Like the name says, their liability is limited to whatever contribution they made or promised to make to the capital of the partnership. Now, that does not mean that they are totally free from liability. They will be liable to any person for any wrongful act or omission that they commit in the course of the business of the limited partnership. Another thing is also that they are also personally liable for their own wrongful conduct, but they will not be liable for the wrongful conduct of other partners. Unlike in a partnership where every partner is an agent of the other partner, that is not the case with respect to an LLP. On the other hand, for a limited partnership, A limited partnership is just simply a partnership. That is, it is an unincorporated entity. However, it has two classes of partners that constitute the partnership. There are a group of partners called general partners, and there are a group of partners called limited partners. The general partners, their liabilities are unlimited with respect to the business, while for the limited partners, their liabilities are limited to what they have promised to contribute or what they have contributed to the capital of the business. The general partners are in charge of the running, the management of the partnership business, while the limited partners do not participate in management. If a limited partner participates in management of the business, his liability then becomes unlimited. So that is a key feature there. The same thing to partnership. Number of partners cannot exceed 20, and the minimum is 2. And like I said, those partners can then be allocated the different categories, and then the legal implications will ensue. Thank you very much.
How are they different from limited liability companies?
So how they are different from limited liability company is this. And a limited liability partnership is different from a limited liability company in that while a limited liability company is a company that has share capital and gives shares to its promoters who are called shareholders, and the management power in that company is vested in the board of directors who may be separate and distinct from the shareholders. The limited liability partnership is a partnership that enjoys the benefit of incorporation, meaning that it now enjoys separate personality that is distinct from the promoters. It can be sued in its name. It can own properties. It has perpetual succession. However, it is still a partnership, and therefore all the partners are entitled to participate in the management of the company. So that is the difference. For a limited partnership, on the other hand, while the limited liability company, like I said, is an incorporated entity that may be sued or sue in its name, own property in its name, and enjoy separate legal partnership personality that is distinct from shareholders. The limited partnership, on the other hand, is merely a partnership. It is an unincorporated entity, and so subject to benefits that it enjoys, that it has a selection of partners whose liabilities are limited to what they have contributed. All the partners are personally liable for the debts of the company. They participate equally in management, and their size is limited.
Can you tell us any benefits of these new structures to investors, entrepreneurs, and professionals?
Essentially, this is appealing to small companies or to specialized businesses. And for the entrepreneur, it gives them an opportunity to formalize their business without incurring the heavy cost that incorporation will impose on them. And so if you have heard the news, you will hear that during the various intervention programs that government had introduced for small and medium scale enterprises, one of the conditions had been that they needed to formalize. And that would have meant that they would need to go and incorporate a company, get company secretary, get board of directors, start doing annual audits, and a lot of things that they may not have the funds to do, or a lot of things that will take fund out of the business into some other things. But with LLP or limited partnership, and for LLP in particular, you are able to have a small entity that does not have the structural obligations of a company, but yet confers on you the benefits, the advantages of incorporation. For what limited partnership helps is for professionals. It allows professionals to capitalize. This will not be applicable to a law firm, but for professionals that are allowed to enter into partnership with non-professionals, you could have partners. So the structure is so that the professionals who will be providing the professional services will be the general partners, while they can then have one or two financiers who will bankroll the business, and they will then be the limited partnership. But that same structure may work with the law firm too, where all the investors are lawyers, but the limited partners will be lawyers who are not interested in practicing, but they will then contribute funds to the business. So it gives flexibility and options for doing business. Thank you.
For further breakdown of the revised Companies and Allied Matters Act by Banwo and Ighodalo, listen to the next episode of CAMA 2020. The business landscape all over the world can either be usual or unusual, depending on who you ask.
In Nigeria, the 2020 amendment to the Companies and Allied Matters Act, otherwise known as CAMA, has added to the level of how usual or unusual the business landscape will be in the country.
So, how will CAMA affect the operations of small businesses,
large corporations,
conglomerates,
voluntary organizations,
non-profit and non-governmental organizations? Banwo and Ighodalo, a Tier 1 law firm in Nigeria, is committed to helping you understand the CAMA 2020 and the implications for your businesses. Listen and get the facts of the Act.